Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss the case of Supreme Bhimandi Vada Manor Infrastructure Private Limited versus State of Maharashtra and another, wherein the Honorable Supreme Court explained the scope of powers exercisable by a magistrate while ordering an investigation in a criminal complaint. The brief facts of the case are that anticipatory bail under Section 438 of the Code of Criminal Procedure 1973 was granted to certain accused persons by the High Court. The accused persons were employees of the appellant company. It was alleged that the accused persons had the responsibility of dispersing the compensation claims of persons whose lands were acquired and that they had forged false documents in relation to a highway construction project under which various farmers and landowners were to be granted compensation in lieu of their land acquired. It was further alleged that such fund for disbursement of compensation was misappropriated by the accused persons. A complaint in this regard was filed before a magistrate who, in exercise of powers under Section 156, subsection 3 of CrPC, directed the police to investigate into the complaint. The accused persons approached the High Court for grant of anticipatory bail that was duly granted to them on the ground that the mandate of Section 200 of CrPC of examining the complainant on oath has not been fulfilled by the magistrate. This grant of anticipatory bail was challenged before the Honorable Supreme Court. Before adverting any further, let us discuss the important provisions of the Code of Criminal Procedure involved in this case. Section 156, subsection 3, it provides powers to the magistrate to order an investigation into a cognizable offence. Section 200, it provides that a magistrate taking cognizance of a complaint, if not made in writing, shall examine upon oath the complainant and substance of such examination shall be reduced to in writing. Section 202, it provides that if the complaint is made by private persons, no order of investigation shall be made by the magistrate unless he examines the complainant and the witnesses. Now let us understand the pertinent observations by the court. Firstly, the court observed that even if a magistrate orders an investigation, the same is not different from an investigation that is conducted by the police. The only difference is that when a magistrate orders an investigation, he does so before taking cognizance of the offense, and the purpose of such investigation is to ascertain whether there is a sufficient ground for proceeding against the accused persons or not. Secondly, according to the court, when a magistrate orders an investigation, the police is duty-bound to register the FIR regarding the cognizable offence disclosed by the complaint, as the police could conduct investigation only after registration of the FIR. Thirdly, the court noted that the powers under Section 156, subsection 3 can be exercised by a magistrate even before he takes cognizance, provided that the complaint discloses commission of a cognizable offence. Thus, Section 200 or Section 202 may or may not come into picture at the time a magistrate orders an investigation under Section 156, subsection 3. Fourthly, the court clarified that while ordering an investigation under Section 156, subsection 3, a magistrate does not take cognizance, and such an order is merely a peremptory reminder or intimation to the police to exercise their primary duty of investigation. Fifthly, the court also explained that Section 202 comes into picture only when the magistrate has taken cognizance of the offence and decides to inquire into the complaint. But if such is not the case, the magistrate has all the powers to order an investigation under Section 156, subsection 3 of CrPC. And lastly, the court observed that while deciding an application for grant of anticipatory bail, the court has to generally consider the nature of the offence the role of the accused, the likelihood of influencing the investigation, the likelihood of fleeing justice, etc. And such grant of bail could be cancelled if the court granting bail ignores relevant material on record or takes into account irrelevant material. Therefore, upon cumulative consideration of the matter, the Honorable Supreme Court was of the view that the allegations against the accused persons relating to misappropriation of funds are serious in nature, and no case for grant of anticipatory bail is made out. Hence, the order of the High Court granting anticipatory bail was set aside. That was all about the case, so what are my concluding remarks? This is quite an informative judgment as it beautifully explains the scope of the powers exercisable by a magistrate under Section 156, subsection 3 of CrPC. It seems that the only requirement to exercise powers under Section 156(3) is that the complaint must disclose commission of a cognizable offense. Once such requirement is satisfied, the magistrate is within its powers to order an investigation even before taking cognizance. Further, if a bail has been granted on extraneous considerations that are not relevant to the case, then such grant of bail could be set aside by a higher court. Hence, I hope you enjoyed listening to this show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.